Noon, and first I just want to express my appreciation to both Justice Scalia and Justice Breyer to being back here in the Senate Judiciary Committee. When having been there for both your confirmation hearings, we didn't have this great room at that time. I also want to thank all the students who are here. I know when I was at Georgetown Law School, I would love to have done something like this. We have scores of students. We have other Americans who are attending this hearing. They're following the procedures over the internet and on television. They're interested in hearing what I hope is going to be a civic-minded conversation about the role of judges under our Constitution. I actually believe such public discussions serve our democracy. As public officials, we owe it to all Americans to be transparent about what we do in our official capacities. We justify their trust by demonstrating how our government works, because it works to uphold our common values, how we're guided by the Constitution, and how that Constitution has served over the years to make our great nation more inclusive, more protective of individual rights, and our continuing effort to become that more perfect union. As the great Chief Justice John Marshall acknowledged many years ago, our Constitution is intended to endure for ages and consequently to be adapted to the various crises of human affairs. In recent months, there have been renewed focus on our Constitution almost every week. I open the newspaper or see an electronic posting that involves some radical invocation of the Constitution. Certainly differs from what I was taught at Georgetown Law Center many years ago. It could be someone suggesting that Congress should just get rid of dozens of judges if that strikes our fancy. Or it might be the assertion that the three branches of our federal government are not of equal importance under the Constitution. Or even the assertion our fundamental charter was drafted solely to limit the federal government's ability to solve national problems. And these comments show the need for more opportunities to increase understanding of our democracy. So that's what gave me the idea to invite two of the nation's leading jurists to speak with us today about the role that judges play under our Constitution. I know in the court, both Chief Justice Roberts and Justice Scalia remarked that the fundamental of the genius of the Constitution is the separation of powers. The legislative, the executive, and the judicial branches each have different powers. They're limited or checked by the other branches, and the three branches interact frequently. We recently observed the 222nd anniversary of congressional enactment of the first Judiciary Act, which established both the Supreme Court and the federal judiciary. And we in the Senate have an obligation to provide our advice and consent to the President to fill a growing number of judicial vacancies. And on this committee, we're working diligently to address the serious judicial vacancy crisis the Chief Justice highlighted in his most recent annual report. I thank the Senator from Iowa for his help in that regard. We've also worked to pass legislation recommended by the Judicial Conference of the United States in order to help the third branch operate fairly and efficiently. We also appropriate resources to fund the important work of our independent judiciary. And the judicial branch, including the Supreme Court, decides cases to resolve controversies in accordance with the rule of law, called upon to interpret and apply statutes passed by Congress to specific disputes, and to review acts of the other branches, determine whether those acts violate the Constitution. And on rare occasions, court decisions can be overturned with legislation or with an amendment to the Constitution. Many of you remember 4 years ago I had invited Justice Anthony Kennedy to appear before this committee to discuss judicial security and judicial independence. It was a great day. The appearance renewed a tradition of justices testifying before Congress on matters other than their appropriation requests, a tradition which included appearances by Chief Justice Taft, Chief Justice 1930s, as well as by Justice Jackson in 1941, among others. I would note that one of my friends said, well, you probably remember those, and I assure you I do not, but fortunately the staff found it. Justice Kennedy recognized that the Supreme Court's rulings would be debated and criticized, but noted that this is a democratic dialogue that makes democracy work. And in further that democratic dialogue, the committee has held several hearings highlighting the significant impact of recent Supreme Court hearings on hardworking Americans. It's been an effort to raise awareness about the relevance of the Court's interpretation of laws that Congress enacted with the intent of protecting American workers and retirees and consumers, small business owners. But today's hearing is designed to have a different focus. Rather than examining recent or upcoming decisions of the Supreme Court, which we will not, we'll discuss the proper role that judges play in our democracy. You know, in a time of increasing political rancor, some like to emphasize divisions as though they're between warring factions. Although the witnesses before us have approached decision-making in many cases in different ways, I know as a personal matter they demonstrate a profound respect for each other. That's also the example that the ranking member and I have tried to achieve in our work together in this committee. American people expect the government to work for them. That requires us to uphold our national values. We all need to work together to uphold a predictable rule of law where liberty and prosperity can thrive. Let me conclude with what Judge Learned Hand said. The spirit of liberty is a spirit which is not too sure that it's right. The spirit of liberty is a spirit which seeks to understand the minds of other men and women. That's the spirit we open this today. And again, I cannot tell you how much I appreciate both justices for being here. And I will, before we begin, I'll yield to Senator Grassley, and then we can yield to the witnesses. Yeah.
Thank you, Mr. Chairman, for holding this very important hearing. I appreciate your efforts to secure the testimony of our distinguished witnesses. This hearing will be an enlightening experience in which we will discuss the role of judges in our constitutional system. And of course, this is a question as old as the Constitution itself, and it will always be debated. I welcome each of our witnesses, and for you, Justice Breyer, you ought to feel right at home here since you served a long time as Chief Counsel of this committee. I remind you of your statement in your recent book, quote, criticism of judges and judicial systems. No, let me start over again. Criticisms of judges and judicial decisions traces back to our founding. It is a healthy thing in a democracy, end of quote. I hope you will feel that way at the end of the hearing. We appreciate that you did not have to appear before us and that your schedule is very busy for both of you. Justice Scalia, I'm also glad to see you here today. As Judge Posner recently remarked, you have, quote, unquote, a real flair for judging. That is an understatement as I see it. You, as much as anyone, have strongly advanced the traditional views that a judge's role under the Constitution is to interpret the law according to the text. For my own part, I believe that the role of judges under the Constitution is an important but limited one. Unless the Constitution provides otherwise, the people, through their elected representatives, govern themselves. In determining the meaning of the Constitution, judges are to apply the intent of the framers, since that is the extent of the limitation on self-government that the people have agreed to impose on themselves. When judges change the meaning of the Constitution and create new rights or grant government powers that it was not intended to have, they reduce the right of people to govern themselves through the representative government process. Historically, these are the circumstances in which judges and their decisions have been fairly criticized. It is rare for sitting Supreme Court justices to appear before the Senate Judiciary Committee, so I thank both of you for sharing with us. Thank you very much.
Thank you. You know, these two distinguished jurists have a lot in common. Both received their law degrees from Harvard. Both serve as Associate Justice of the Supreme Court. Prior to their confirmation by well-respected administrative law scholars. They're both elevated from positions on the federal appellate bench. Justice Breyer served in the First Circuit, Justice Scalia on the D.C. Circuit, and I actually one of the few here who had a chance. I voted for both of you on the Circuit Court and both of you on the Supreme Court, and was there for the hearings on both times. Now, despite their different perspectives on constitutional interpretation, they were confirmed by a whopping margin. In the past, they've agreed on the importance of precedent, judicial independence, respect for democratic decision-making. Justice Breyer has been on the Supreme Court for 17 years. Justice Scalia, a quarter of a century. And I understand we left up to you who you wanted to go first. And I think I just got the word from Justice Scalia. In case I ever have to practice law again, I'm listening. So Justice Breyer goes first. Is your mic?
Yeah, no. That I would go first to introduce the question as we see it, and we're both very glad to be here, particularly because I did work here, which I loved, but also because you've invited high school students, college students, law school students, and we both talk to those groups of students a lot, and we want to do that. And the reason we do, in special part, is because there's a lot of skepticism and then cynicism about government in the United States. And I'll say to the students, I understand that, and probably some of that is justified, but if there's too much of it, well, the government just won't work, because you're part of the government, and if you're not going to be part, we don't have a government. That's what I want to tell them. All right, now how can I tell them that? How can I do my bit on this? Well, I'm a judge. You know, I don't run for office. It's hard to get people's attention on a general question like that. But my bit consists of trying to explain my institution. What is it I do? What is it that Justice Scalia does? What do we do every day? What do we do that affects those students and that they'll have to understand, explain to their parents and to others? And the way I put the question, and this is really all I'm going to say first, is how I think of the question. And I think from my institutional point of view, I want to tell people why maybe they'd give our institution support. Suppose I have the attention of a man or a woman who's going into a supermarket. Now, that's tough to get their attention. That woman says pretty busy. They may have 2 jobs. They may have a growing family. They have bills coming in every month. And they don't have too much time to listen to judges. So but suppose I get their attention on this question for just a few minutes, what would I say? The first thing they say is, what question? I'd say, I have to tell you what the question is. The question is, the 9 of us are not elected, but we live in a democracy. And we do decide matters that will affect you. So why should 9 people who are not elected have that authority? And it's worse than that. Because if you look at why Hamilton gave us the power, and why the founders gave us the power to set aside a law of Congress contrary to the document, the Constitution. You read Federalist 78. Well, you know, she may be asleep by this time, but I have to get her attention and say, well, in Federalist 78, here's what he says. He says, first, look at the document. It's a great document, and it is. But if nobody's going to say when anybody else goes beyond its boundaries, let's hang it up in a museum. Let's put it in the National Gallery. Well, actually, he didn't say the National Gallery because it wasn't built at that time. But nonetheless, you understand the point. He says somebody should have that power. Who? The president? Well, the president has an awful lot of power. He could become a tyrant with that as well. Well, what about Congress? Congress is elected. He says, yes, that's the advantage, but that's also the problem, because Congress will have just passed a law because it's popular. This document gives the least popular person in the United States the same rights as the most popular. Are you sure Congress, having just passed that law, will turn around and say it's unconstitutional when it's very unpopular to do so? But here we have some judges. They're sort of bureaucrats. Nobody knows who they are. Fabulous. This has something to do with law, doesn't it? And they don't have the power of the purse, and they don't have the power of the sword. Wonderful. They don't have much power. And in addition, they're sort of judges, and it's not Congress and not the president. And he stops there. So I say, ma'am or sir, we are not elected. We are supposed to decide things that are unpopular on some occasion. And you know what? Don't tell anyone. We're human beings, and we may be wrong. Indeed, when I'm in dissent, I do think the majority is wrong. And so does Justice Scalia. And we can't both be right if we're opposite sides. So there we are, unelected, doing unpopular things, and quite possibly wrong. Why should you ever give us your support? And that's the question. And I get that question not just from people in supermarkets, not just from students or their teachers. I get that question from people all over the world. There are judges in our court that come to visit. There are Latin American judges or Asian judges. Or there was a woman who was Chief Justice of Ghana, and she posed that very question. She says, why do people do what you say? It's, you know, they have Henry IV over here. It's sort of Hotspur's question. Hotspur says, I can call spirits from vasty deep. Or Owen Glendower says that. And Hotspur says, so can I, so can any man, but will they come when you do call them? And to answer that question, I have to give a little synopsis of history. But all I was doing in these 4 minutes was sketching out the question. And then I will turn to my colleague who can address that or anything else he would like.
Thank you, Mr. Chairman, members of the committee. I'm happy to be back in front of the Judiciary Committee where I started this pilgrimage. I am going to get even more fundamental than my good friend and colleague. Like him, I speak to students, especially law students, but also college students and even high school students, quite frequently about the Constitution. Because I feel that we're not teaching it very well. I speak to law students from the best law schools, people presumably especially interested in the law, and I ask them, how many of you have read the Federalist Papers? And well, a lot of hands will go out. No, not just number 48 and the big ones. How many of you have read the Federalist Papers, cover to cover? Never more than about 5%. And that is very sad. I mean, especially if you're interested in the Constitution. Here's a document that says what the framers thought they were doing. It's such a profound exposition of political science that it is studied in political science courses in Europe. And yet we have raised a generation of Americans who are not familiar with it. So when I speak to these groups, the first point I make, and I think it's even a little more fundamental than the one that Stephen has just put forward, I ask them, what do you think is the reason that America is such a free country? What is it in our Constitution that makes us what we are? And I guarantee you that the response I will get, and you will get this from almost any American, including the woman that he was talking to at the supermarket, the answer would be freedom of speech, freedom of the press, no unreasonable searches and seizures, no quartering of troops in hope, those marvelous provisions of the Bill of Rights. But then I tell them, if you think that a Bill of Rights is what sets us apart, you're crazy. Every banana republic in the world has a Bill of Rights. Every president for life has a Bill of Rights. The Bill of Rights of the former evil empire, the Union of Soviet Socialist Republics, was much better than ours. I mean it literally. It was much better. We guarantee freedom of speech and of the press. Big deal. They guaranteed freedom of the speech, of the press, of street demonstrations and protests, and anyone who is caught trying to suppress criticism of the government will be called to account. Oh, that is wonderful stuff. Of course, just words on paper, what our framers would have called a parchment guarantee. And the reason is that the real constitution of the Soviet Union, you think of the word constitution, it doesn't mean a bill, it means structure. Say a person has a sound constitution, has a sound structure. The real constitution of the Soviet Union, which is what our framers debated that whole summer in Philadelphia in 1787. They didn't talk about the Bill of Rights. That was an afterthought, wasn't it? That Constitution of the Soviet Union did not prevent the centralization of power in one person or in one party. And when that happens, the game is over. The Bill of Rights is just what our framers would call a parchment guarantee. So the real key to the distinctiveness of America is the structure of our government. One part of it, of course, is the independence of the judiciary. But there's a lot more. There are very few countries in the world, for example, that have a bicameral legislature. Oh, England has a House of Lords for the time being, but the House of Lords has no substantial power. They can just make the Commons pass a bill a second time. France has a Senate, it's honorific. Italy has a Senate, it's honorific. Very few countries have two separate bodies in the legislature equally powerful. That's a lot of trouble, as you gentlemen doubtless know, to get the same language through two different bodies elected in a different fashion. Very few countries in the world have a separately elected chief executive. Sometimes I go to Europe to talk about separation of powers. And when I get there, I find that all I'm talking about is independence of the judiciary, because the Europeans don't even try to divide the two political powers, the two political branches, the legislature and the chief executive. In all of the parliamentary countries, the chief executive is the creature of the legislature. There's never any disagreement between them and the prime minister, as there is sometimes between you and the president. When there's a disagreement, they just kick him out. They have a no-confidence vote, a new election, and they get a prime minister who agrees with the legislature. And, the Europeans look at this system and they say, whoa, it passes one house, it doesn't pass the other house. Sometimes the other house is in the control of a different party. It passes both, and then this president who has a veto power vetoes it, and they look at this and they say, it is gridlock. And I hear Americans saying this nowadays, and there's a lot of it going around. They talk about a dysfunctional government because there's disagreement, and the framers would have said, yes, that's exactly the way we set it up. We wanted this to be power contradicting power, because the main ill that beset us, as Hamilton said in the Federalist, when he talked about a separate Senate. He said, yes, it seems inconvenient, but inasmuch as the main ill that besets us is an excess of legislation, it won't be so bad. This is 1787. He didn't know what an excess of legislation was. So unless Americans can appreciate that and learn to love the separation of powers, which means learning to love the gridlock, which the framers believed would be the main protection of minorities, the main protection. If a bill is about to pass that really comes down hard on some minority, they think it's terribly unfair. It doesn't take much to throw a monkey wrench into this complex system. So Americans should appreciate that, and they should learn to love the gridlock. It's there for a reason, so that the legislation that gets out will be good legislation. And thus conclude my opening remarks.
You may not get total unanimity on the issue of a gridlock, but I found listening to both of you to be fascinating, and I made a little note to myself. This is for everything that might go wrong this week, and all of this makes up for it, just having both of you here. So I do appreciate that. Justice Scalia, the court, of course, often reviews laws passed by Congress. I apologize for the voice, it's an allergy, but when the court reviews a law passed by Congress and you want to find out whether it comports with the Constitution, do you have a different standard if it was a law that passed by the slimmest of margins, or if it's a law that passes overwhelmingly? And I'll ask that question to both of you.
No, sir. A law is a law. meets the requirements of the Constitution, having passed both houses and either being signed by the president or having been passed by 2/3 over his veto, it's a law. And what we do is law.
Justice Breyer?
Yes. Yes, sir. I agree.
And Justice Scalia, under our Constitution, what is the role, if any, that the judges play in making budgetary choices or determining what's the best allocation of taxpayer resources? Is that within their proper role, or is that somewhere else in the...
Oh, you know it's not within our proper roles, Mr. Chairman. Of course it's not. Of course it's not.
It's when we try to talk about this document in general, what I say, and he'll have some version of it, is what does this document do, the Constitution? Well, I say I can't tell you in one word, but I can tell you in about 5. It creates a structure for democracy. That's the first part. That's the whole 7 articles. It's a structure so people can make their own decisions through their representatives and decide what kind of cities, towns, states, and nation they want. But it's a special kind of democracy. It guarantees basic and fundamental rights. It assures a degree of equality. It does, as Justice Scalia has emphasized, separate power both vertically, state, federal, and horizontally, 3 branches, so no group of government officials can become too powerful. And it insists upon a rule of law. So now we have 5 basic things, and I tend to think the rest of it elaborates those 5 basic points. And I think probably Justice Scalia and the others we're not in disagreement at that level, very rarely. So what people don't understand very often is, given those broad boundaries in this democratic process, we're the boundary patrol. Did you ever listen? There used to be some kind of radio program called Sky King of the Mounties or something. It was something like that. I can't get it.
Because before my time.
Yeah, no, yeah, it wasn't.
Right.
But well, look, it said
It was Sky King and Sergeant Preston of the Mountains.
Sergeant Preston of the Yukon. That's it, the Yukon. It was cold. It's on the boundary. It's very cold. Life on the boundary is tough. And we are, in a sense, the boundary patrol. And those issues are very tough. Is a choice inside, outside. What about prayer in schools? What about this or that? There are 2 sides to these questions. They're tough ones. And what people forget is just what you were emphasizing with the budget question, that inside those boundaries, there is a vast democratic space where it is up to the average American to decide what kind of cities, towns, state, and nation he or she want. And those decisions are not ours. All we can say with a forum like this is, please participate in that democratic decision-making, which is not our institutional job.
Well, excuse me, with a smile on Justice Scalia's face when I asked the question, I think he's probably anticipating some of the next questions. And so I'll start first with you, Justice Breyer. In your book, Making Democracy Work, you describe how the court system relies on the public confidence because it has neither the power of the purse nor the sword, as you both alluded to earlier. And so then people ask, well, is the rule of law predictable? Because Americans rely on certain programs and so forth. Do you feel the public's confidence is affected when judges overturn longstanding precedent, when a settled expectation, if they have something that people relied on for generations, and then suddenly it's overturned? What does that do with public confidence, and what does that do for our the rule of law? You have neither the purse nor the sword. You have, however, the question of what confidence the American public has. So, Justice Breyer, you want to try that first?
On that, I think there's no definite answer. You want to say never, what you give as reasons against overturning something are strong reasons. But Plessy v. Ferguson, which said separate but equal should have been overturned, and Brown versus Board of Education, which said no more racial discrimination, was absolutely right to overturn it. So I think your advice is good. It means that the judge has to remember not too much, not too fast, not too often. Be careful. People have relied on formal law, but you cannot say never.
Justice Scalia?
Yeah, I think part of the jurisprudence of my court and all federal courts is stare decisis. It's not an absolute rule, but it is a subject that should be given careful attention. And all federal courts have given stare decisis very much more weight in statutory questions. It's very rare that my court would overrule a prior decision on a statutory point. The reason being, if we got that wrong, you can fix it. You can amend the statute. But when we get something wrong with respect to the Constitution, there's nobody that can fix it unless you're going to go through the huge trouble of enacting a constitutional amendment.
Well,
So throughout our history, there's been a rule of stare decisis, but beginning with the Marshall Court, it's been less strict in constitutional questions than it is in statutory questions, and I think that's as it should be.
Well, and of course it's easier for the lower courts if there is a binding, if the district court is a binding circuit court opinion, if the circuit court is a binding Supreme Court. But the buck really stops with you 9. Now, you talk about amending the Constitution. We obviously amended it. The 13th Amendment got rid of the state. Nobody could think of that having now 15th, racial discrimination, 19th, giving women the right to vote, 24th, young adults, and so on. And Justice Scalia, I've read some of your works, and I hope I'm paraphrasing it correctly, that we should not mess with the Constitution by amending it. Since I've been here in the Senate, I've seen probably 1,500, 2,000 constitutional amendments been proposed. It's probably even more than that. I mean, you get them from things that I think a board of aldermen in a small town would not have thought of doing because it was so ridiculous. But and some have serious issues. But is it in our country's interest to be tampering with the Constitution if that can be avoided?
Well, no. This is another respect, by the way, in which we differ from most of the countries of the world. Many foreigners can't understand our affection for the Constitution. It's no big deal to amend the Constitution in most of the countries of the world. In most of them, all you need is to have the legislature, a unicameral legislature, pass the amendment. Then there has to be an intervening election, and then they have to pass the amendment again.
But their Constitution is almost like a statute.
It's almost like a statute, except that it has to be passed twice with an intervening election.
Sure.
Ours is very much more difficult to amend, and you're right. I have said that that's a good thing. Indeed, I've said that the only provision I am sure I would think about amending is the amendment provision, because that sets a very, very high pole. But that's not going to happen, so I'm not worried about it.
Justice Breyer, my time has run out, but would you like to respond on that too?
I tend to agree with that.
It's going to surprise the rest of the court to find out how much you
Look, we're unanimous in our court 40% of the time. Our 5-4s are about 20 to 25%, and surprisingly enough, it isn't always the same 5, the same 4.
And you should be suspicious if we don't have a lot of 5-4 decisions, because the main reason we take a case is that there is a circuit conflict below.
Yeah.
That is, very good federal judges who have been appointed the same way Justice Breyer and I were appointed have disagreed. So you would smell something wrong if there are these disagreements below, and the Supreme Court always comes out 9-0 one way or the other. You should expect a lot of 5-4 decisions.
Thank you. Senator Grassley.
Yeah, I'll start with Justice Breyer and a couple questions based upon a recent C-SPAN interview that you had. You remarked that although judging is not entirely about politics, you would, quote, not say zero politics, never. So
That's one of the hardest things to explain, and that's part of what I've written about in this book. I think there are two great questions that I want to get across to the audience, if it's a high school, college, law school, particularly. First is the one we mentioned. When you call them, will they come? Why is it that Americans over the course of 200 years have begun to have responded to the Supreme Court? And there's some good stories on that, but I put that to the side. The other thing I put this way. I say, I know you're being very polite, but I also know a lot of you are thinking this. You're thinking in those tough 5-4 cases, what we really are junior league politicians. And I say that would be ridiculous. For one thing, that's not the job. I mean, didn't Hamilton give us the job because he thought we wouldn't be politicians? And second, read a case like Dred Scott, one of the worst, probably the worst ever. There, the most you can think of why they were doing this is they were trying to act like politicians. Well, judges are terrible politicians. If you wanted to give this job to politicians, give it to Congress. I mean, we know nothing of, we're not, well, no, all right, any case. So how do I explain it? I explain it this way. I say, in the 17 years since I've been a judge, do I see a decision turn on political considerations? I did work in this committee. I have an instinct that politics consists of who's got the votes. Is it the Democrats or the Republicans? Who's popular? Who's going to win the election? And in that sense, I have to say my answer is never. And I know you'll think of this case or that case where you think that's wrong. I need an hour to explain it to you, but I think I could bring you around. So that point, what about ideology? So ideology, are you a Adam Smith free enterpriser? Are you a Marxist, Maoist troublemaker? You know, what's good in general for the world? I say, if I think I'm thinking of it that way, I know I'm doing the wrong thing. But I can tell you there's a third thing. I was born in San Francisco. I went to Lowell High School, a public high school. I went to the university out there. I've lived the life I've led. And by the time you have 40 or 50 years in any profession, you begin to formulate very, very general views. What is America about? What are the people of America about? How in this country does law relate to the average human being? How should it? At that level of generality, people may have somewhat different outlooks. And there's no way that those different outlooks can fail to influence them some. And is that a bad thing? No. I think it's a good thing. This is a very big country. We have 309 million people, 308 million of whom, to everyone's surprise, are not lawyers. You know? And they have many different views. And it's a good thing, not a bad thing, that people's outlook on that court is not always the same. And by outlook, I mean those very, very basic ideas of judicial philosophy, if you like, or about the country and its people and about the law and how judges are there to act and what they're to do and what not. So that's what I meant by that word there.
Okay, and I'll start with Judge Scalia on my second question. Why would it ever be appropriate for an American judges to consider foreign law in interpreting the meaning of the United States Constitution? And Justice Breyer can respond as well.
Senator, I'm afraid we're getting beyond what I had planned to discuss with you gentlemen, the role of the courts, and we're getting into the manner in which the courts go about deciding their cases. And I have a view on that, and Justice Breyer probably has a different view. But I haven't prepared any testimony on that, and I'd rather pass. I just, of course, it's an issue, and I think my views on that issue are known. But that is not the level of what should I say?
Let's move on now.
Okay.
To both of you, discussing the Supreme Court, Justice Brandeis stated, quote, "The most important thing that we do is doing nothing, And to what extent do each of you agree with that?
It depends on the case, but it's important. Yeah, I don't know if it's the most important. I'm not sure what he was thinking of. What do you think on that?
Well, yes, I think the normal state of things is rest. Leave things alone unless there's reason to change it. Well, I served in the executive branch for a while, and there was when I was there was something that came to be known as the Moscow option, which sounded, like it's a CIA stuffer. It was named after a fellow named Mike Moscow, who was one of the president's assistants, and he observed that whenever action memos went into the president, they always gave the president three options. Number one, do X. Number two, do the opposite of X. And number three, do what whoever wrote the memo wanted, which is somewhere between X and the opposite of X. And Moscow noted that you will never see among the options, do nothing. And that very often is the right answer. But it's certainly the case for courts. Don't make waves unless unless there's a reason for a change. Unless what the Congress has done or what an agency has done is wrong, you leave it alone.
What your question brought to my mind was there's something in Tocqueville which is really I like the students to read Tocqueville too, because it's amazing in 1840 what he's writing, and you think, my God, he wrote it yesterday about this country. And one of the things he says, which really stuck, is he says, whenever I come to the United States, the first thing that strikes me is the clamor. Well, what's he thinking of? He means everybody's screaming at each other is what he meant. And what he really meant is they're debating. They're talking about things. They're disagreeing. And he thinks that's good. And I do too. Because suppose you have a really tough problem. Sometimes let's imagine when you're trying to figure out some bill and it has to do with privacy and it has to do with free expression. And there are all kinds of tensions right there with the internet and the new methods of communication and Twitter and Facebook or whatever they are, and people privacy. And you're more familiar with all those than I. How do we decide those in this country? I think the general word I use to talk to about that is the word bubbling up. The first thing that happens, people start to talk. They talk in newspapers, they talk in classrooms, they talk in articles, they talk in small groups, they talk with a policeman, they talk with a fireman, they talk with the civil liberties groups, they talk to everybody under the sun, and they begin to debate and they get into arguments. Eventually it gets to you. You have hearings. You eventually decide maybe an agency should do it. Maybe we should have a statute. Maybe we change our mind 5 times. And eventually things will settle down. And what I say about my court, it's really wonderful if we do not get involved until it settles down. Because our only job is going to be to decide if what you decide is within boundaries. And it's going to be a subject where we will know less about it than those Americans who have gone into it in depth. So be careful of intervening before this big debate, this clamor that Tocqueville's talking about, has a chance to take over, take effect, scream, change, try it on, try it off. And I think that's really the wisdom that underlies this view of don't decide too much too fast.
And we do a lot of nothing.
We do.
I told you that the main reason we take a case is because there's disagreement below. But if there's no disagreement below, we don't get involved. We don't go prowling around looking for congressional statutes that are unconstitutional. It's only when there's disagreement below that we take a case, with rare exceptions. If a lower court has found one of your laws to be unconstitutional, we'll take that, even though no other court has held the opposite. But except for rare situations like that, we let sleeping dogs lie, which is the way one should live his life, I think.
Go ahead. Thank you. Senator Cole.
Thank you, Mr. Chairman. Justice Scalia, in your opening remarks, you talked about how brilliant our system is, our Constitution, and the kind of disagreement it provokes, and how difficult it is to get things done. That's the greatness of the American Constitution, in contrast to so many other countries. And yet, we are described now by people all over the country as dysfunctional, as unable to get anything done. And the level of dissatisfaction is is up to about 88 or 90% now among the American people, because they say we can't get anything done, that the system doesn't work. How do you respond to them?
Well, I suppose there is a point at which you do reach gridlock. However, I think the attitude of the American people, and this is the point I was making, is largely a product of the fact that they don't understand our Constitution. That its genius is precisely this power contradicting power, which makes it difficult to enact legislation. It is so much easier to enact legislation in France or in England. But, you know, the consequence of that is you have swings from one extreme to another as the legislature changes. That doesn't happen that much here, largely because of the fact that only laws on which there is general agreement, as a general matter, only those laws will get through. So, you know, I think this is one of the reasons why we have to educate the American people, as we have not been doing for decades, about what our Constitution produces and what it is designed to produce.
No, we've discovered it's the same problem Sandra O'Connor is always talking about. I mean, we're limited in what we can do, and probably you are, but she's out there nonstop trying to get civics restored to the high school curriculum. He says I mean, what do most people think about it, taking a case which we were just discussing? I bet if you did a survey, those who know anything about it would say, oh, they sit up in that big building and they just decide this would be an interesting subject. Let's decide it. I mean, that is very far from the truth. We have a system, as you've heard described. So what we try to do is talk to people. Annenberg does that, the foundation. They're in 55,000 classrooms. And Sandra and I, and sometimes Nino, have discovered that it's very useful to get a film taken of a case or something of something in the past and have us comment and try and get it in the high schools. Vartan Gregorian's trying to do that with Carnegie. You have a very different institution, but you do try to communicate with the public quite a lot. And all I can say is it's probably harder for you than it is for us. But to get across the idea that the student today has to know how government works, they have to know something about their history, and they have to be willing to participate. It's very easy to say, and it's very hard to get across.
Gentlemen, as you know, you have the power to decide cases themselves, but your power is also to decide which cases you're going to hear. And you have some 8,000 opportunities to make decisions every year on the cases you're going to hear, and last year you decided to hear 77 cases, which is just 1% or less than 1%. So what goes through your minds collectively when you decide on which 1% you're going to hear, and what do you say to the 99% who don't get heard?
The latter, we say denied. But for the former, you're quite right. There ought to be some rules. It shouldn't be random. It shouldn't be, you know, whatever tickles my fancy. And that's why we have a general rule that unless there's a circuit conflict, you're wasting your time and your client's money to file a petition for certiorari. It is overwhelmingly likely that we will not grant it. So it is not the case, I assure you, that we prowl about looking for an issue that we want to get up to the court. I don't know any of my colleagues that behave that way. I think they all have standards. Is there a circuit conflict? Is it a significant issue on which the lower courts are divided? Okay. And for the others, I'm surprised it's only 8,000. I thought it was up to 9,000 now. And by the way, when I first joined the court, it was only 4,000. That's how much that's increased. So it is now a fairly large part of our job, just deciding what we're going to decide. Every one of us looks at least summaries of all 9,000 of those petitions.
There are 150 a week in memo form that come into the office, and the originals are back there on my shelf. Now, I bet if we sat down tomorrow, the two of us, even though it's not part of your job, I'll make an initial cut, and maybe it'll be like 140 and 10. And I bet if we were there together, the cut that you would make would not be much different than the one I would make. It's interesting. It's why? Because they sort of speak out. And the only other thing I'll add is in the conference, I know there are groups of lawyers particularly like to see us take more cases, and the other people who'd like to take more cases in a sense is us. When Sandra was on the court, and I think she said this publicly, I mean, said, we've got to get more cases here. Nobody's making an effort to take fewer. That's not the attitude in the conference. The attitude in the conference is there's a split. Yeah. Let's take it. We have room. We have room. To hear more. Nobody's thinking that there isn't the room.
Well, let me just respectfully disagree, and perhaps you can respond. When you came on the court in 1987, you heard 277 cases that year. And when you came on the court, Justice Breyer, that year you heard 105 cases. Last year you heard 77 cases. So I don't understand.
Senator, we never heard 277. When I came on the court, I think we were deciding about 150. And I will tell you, I don't think we can decide 150 well. If you go back and look at our opinions in those days, if you ever read an opinion in which the majority opinion and the dissent are like ships passing in the night, they never quite meet each other, you turn to the first page and you will see that it's a June opinion because we were rushing out opinions at the end of the term. I don't think we can do 150 well. I think we could do 100 well. And frankly, I'm probably voting to take some cases that I wouldn't have voted to take 10 or 15 years ago. But it's not as though we sit down at the end of the year and say, okay, let's take 75 cases. Let's pick the best 75. That's not what happens. They trickle in week by week, and we vote on the ones that week that seem worth taking. And at the end of the term, they've added up to whatever they've added up to. If my standards have changed, it's only because I'm trying to take more rather than I'm trying to take less. I suspect that the major reason for the decline was that when I first came on the court, there was a lot of really breathtakingly important new legislation. And a new bankruptcy code, Title VII. In the last 10 years, there's been legislation, but very little of that magnitude. The major generator of circuit conflict below is new legislation, because it always has some ambiguities that have to be decided by the courts. So where there hasn't been a whole lot of major new legislation, you would expect our load to go down.
I agree with that. But it's just a theory. We can't measure it. But every word in a bill is an argument. Every word you pass, there are lawyers who can, decide. And so if a lot of legislation is passed, then I think with a 5 or 10 year lag, you'll suddenly see a lot of cases in the Supreme Court. And if you go 5 or 10 years and there's less legislation passed, fewer words, you will discover a diminished number of conflicts among the circuit. So you look at our, when you pass the habeas law, then go back out 2 or 3 years, and suddenly you'll see lots of habeas cases coming up to us. And the same is true with IIRA, the immigration thing. So you're now passing laws with thousands of pages, not budgetary laws, but laws that are likely to come to us. My guess is with a lag, that caseload will start going up.
Thank you.
We're about to go to Senator Hatch, and I've been sitting here trying to resist temptation, and I won't. When you mentioned from Henry IV the discussion of Glendower, you have that in your book, and I noticed it earlier when I was going through your book. It is one of my all-time favorite quotes, usually to express exasperation somewhere. Senator Hatch.
Well, thank you. I personally appreciate both of you being willing to do this. I think it's a very, very good thing. And I know it's unusual for you, and so I'm grateful for the chairman for calling this particular meeting. And I'm particularly grateful to both of you. You both have been great justices. You've been on the courts for a long time. And you've decided a lot of important cases. And we now have, this year, it looks like a docket that's going to be pretty doggone important compared even to past years. Let me just say this: when
You
federal
sound happy about it, Senator.
I am.
I'm not sure I am, but
well, I'm very happy. I think I want you working really hard, Justice. And you too, Justice Breyer. I have great hope for you. There's no question about that. Now, I remember you when you were here on the committee. You were a terrific Chief of Staff for Senator Kennedy, and you meant a lot to us then, and you mean a lot to us now. Let me just say, when federal judges construe our statutes, they try to figure out what we meant by what we said. Legislators on both sides of the aisle would object if judges changed the meaning of the statutes we enact. And as you know, we even differ on that. But who knows? We might even hold a hearing about it. You never know. But the point is that even if we don't express clearly what we mean, it is still our meaning that counts. Should the basic approach be any different when judges interpret the Constitution? In other words, if statutes do not mean whatsoever judges say they mean, how can the Constitution mean whatever judges say it means? Sure.
In a sense, the answer is it shouldn't. When I have a statute, I think all judges, when they have a text, and the text isn't particularly clear or there are questions, they all have the same weapons. You read the text, you look at the history, you look at the traditions around the word, say it's habeas corpus, a lot of tradition there. You look to the precedents, you look to what I'd call the purposes or the values, and you look to the consequences read in terms of the purposes or values. So if I have a statute, the first thing I want to know is somebody wrote that statute. These words may be hard to figure out what they mean one way or the other, but somebody had something in mind in Congress, and I want to find out what that is, and I want to stick to it. Now, when you're talking about the Constitution, because there are words like liberty, or because there are words like freedom of speech, the freedom of speech, it's not so much purposes that I would use to describe that. I describe that as basic values. And I think those basic values that were enacted in the 18th century have not changed, or at least not much. The values are virtually eternal, but the circumstances change. So I say, sometimes when we discuss this, which Justice Scalia certainly knows and agrees with, George Washington did not know about the Internet. And a lot of our job is to apply the values that are there in the Constitution, which really don't change, or at least not much, to circumstances that change all the time, every 5 minutes. And that isn't so easy to do. Put at the level you've put at, which I think is a very good level. Should we follow those purposes in terms of the values of the framers? Absolutely, yes. In terms of trying to apply it to situations that they did not foresee, well, there I think you can't do that. I think you have to figure out how those basic values apply to the world today. A world that is international and national in terms of commerce, in terms of the Internet, in terms of 1,000 different things that face you every day. And then how much emphasis you give to what and trying to answer that question is a matter that sometimes divides judges. But the need to answer it, I think, is a matter that unites them.
yeah, I don't agree with most of that.
You don't?
In fact, I hate to say this, but I'm not sure I agree with the premise that our object is to figure out what Congress meant. I think our object is to figure out what the law says. If Congress meant one thing but enacted a law that says something else that is promulgated to the people, I am bound to apply the law. That's what it means to have a government of laws, not of men. And that's why I don't use legislative history. I'm glad Senator Grassley is gone, because I know this is one of his pet peeves. That's why I don't use legislative history, but Justice Breyer does. I think we're governed by laws. And when I approach a statute or the Constitution, I ask myself, what do these words mean to the people to which they were promulgated? And once I figure that out, I can sleep at night.
Well, I think it may take a few more years, but I'm confident you will. Let me just say it is common today for people to evaluate judges and their decisions based on what people want judges to do or on whether they like a judge's decision. Both liberals and conservatives do that. I'm looking for a more principled or objective job description for judges.
Very hard.
Given the title of this hearing, does the Constitution itself offer anything to help define the role of judges? And is there some practical, concrete guidance we can draw from the Constitution itself as a way of defining what judges are supposed to do?
That's good.
Whichever you want me to start.
Sure.
Boy, that's that is a hard problem. Your intro suggests a point that I wanted to make to the committee. One of the difficult things about the job that Steve and I have is we are criticized in the press for our opinions, and of course we can't respond to press criticism. That's just the tradition. But usually, the criticism in the press and the reaction of the public to the opinion has nothing to do with the law. If they like the result, it's a wonderful opinion, and these are wonderful judges. And if they dislike the result, it's a terrible opinion. They don't look to see what the text of the statute is that was before us and whether this result is indeed a reasonable interpretation of that. None of that will appear in the press reports. They'll just tell you who the plaintiff was, what the issue was, and who won. And if you like the result, it's a great opinion. If you don't like it, it's terrible. That's just one of the disabilities we operate under, and that's one of the reasons we're not supposed to advert to whether the public likes our opinions or not. We're supposed to just go down the middle and interpret the text as we think it ought to be interpreted. Now, how you can you're quite right that when those who don't like one of our opinions, we'll call it judicial activism. Judicial activism always consists of the court doing what you don't like it to do. I suppose there is some...
We understand that.
I know that. I don't know any solution for it, Senator.
Well, it isn't a solution. It isn't a solution. I mean, we're both judges. We've been judges for a while. We have a rough idea of what it is to be a judge. And we both know that what we're trying to do is apply the law and interpret the law. No one at that level disagrees. All right, you say, well, how do you do that? And I think I can get a little more specific before I'll find disagreement. And that's why I mentioned those things of reading the text. You know, if the text says fish, that does not mean carrot. A carrot is not a fish, no matter what your intent. You have to follow those words, and it rules out a lot of things. All right, so the words are there, and the history is there, and the tradition is there, and the precedent is there. And the purpose, it may be hard to find sometimes, but sometimes it's not. And the consequences, you don't know all of them, but you know some of them, and you said some evaluation in terms of those purposes. So we'll try to do that. And Justice Scalia may place more weight on some of those things, and I'll place more weight on purposes and consequences, but that's putting different weight on different parts of tools that we all have. And then when we get into the constitutional area, I might say, look, I'm looking to values and how they apply today, and he might think he can find more in history. But I can see that. I'm not going to say history is irrelevant, and I don't think he'll say that sometimes you just don't find that much there, at least sometimes. And so it's a question of degree and so forth. But the bottom line for an appeals court judge, and it's a very useful bottom line, is you have to write an opinion. And that opinion is going to be based on reason. You can't prove it. It's not logic. We're not computers. But I can honestly set forth my reasons for saying it's this way rather than that way. And he does the same. And one of the great things about dissenting opinions, if he writes a dissent or I write a dissent, he'll read it. And I'll read it. And I'll respond. Because I'm not going to let him, put in quotes, get away with that, or I'm not going to let him, he's pointed out something, I don't know how that got in my opinion, I better change it. And so this strengthens the opinions. Yeah. And ultimately they can be read by the public, right. And they are read by some of the public. And the strength there is in its reasoning, tied back to the documents and tied back to this country and tied back to a lot of things. But there's the basis there for criticizing and for valid criticism and valid praise or blame of a particular judge. And of course, we love it if people take the opinion at that level rather than responding simply to a press report. But I think pretty much that's what we see as the job.
In some ways, I feel like I'm back in my favorite seminars in law school, and which is a lot more fun than sometimes being in the Appropriations Committee or some of the other things doing this. But I do want to move this along. I've tried to give extra time to everybody just because of the justices' time. And I'll go now to Senator Feinstein, just so we know what the order is. I have, and I received this from Senator Grassley. On the Republican side, it'd be Senator Graham, Cornyn, Lee, Coburn, and Sessions. On our side, Senators Feinstein, Blumenthal, Durbin, Whitehouse, and Coons. Senator Feinstein.
Thank you very much, Mr. Chairman, and thank you for holding this hearing. And justices, thank you very much for being here. I was looking at the faces in the audience, most of them young, all of them listening and interested. And I think really what it says is the respect that we have for the rule of law in this country, and that highest order of the rule of law rests with the authority that you have. And I, for one, am very, very proud of it, and I'm always proud when I travel that America is represented by the distinction of this great court. And now, I want to ask you something about the 14th Amendment, and if both of you could respond to it. It's simple. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Is a woman included within that definition?
Yeah. A woman's a person. I think that's well established.
Yeah, the issue is not whether a woman's a person. The issue
Where I'm going.
The issue is what constitutes equal protection.
Yes, all right. Are women included?
Yeah.
Of course they're included.
Yeah.
Well, let me ask you.
But does equal protection mean that you have to have unisex toilets? I mean, that's the kind of question you have to get into.
This is your quote, Mr. Justice, in California. Certainly, the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that's what it meant. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures, and they enact things called laws. So why doesn't the 14th Amendment then cover women?
The 14th Amendment, Senator, does not apply to private discrimination. I was speaking of Title VII and laws that prohibit private discrimination. The 14th Amendment says nothing about private discrimination, only discrimination by government.
Yes.
So, oh, I see what you meant.
Yeah.
Okay. All right. If I can, let's go to Justice Scalia. I think in the past you've advocated a constitutional interpretation called originalism, in which the meaning of a constitutional provision is determined based on the provision's meaning in 1789. And you have also said that government, even at the Supreme Court level, is a practical exercise, and that, well, let me just say what I'm trying to think. In other words, that the Constitution should be interpreted for its meaning at its origin. And Justice Breyer, you have taken the position that the Constitution is a living document, and therefore it adjusts to times and changes within this government, within the time period. Could each of you give us your legal interpretation of that and how you approach it?
You start. I started last.
I mean, it's not quite as starkly different as is sometimes painted.
It's pretty.
I mean, yeah, because it's pretty different. All right, I tend to think that the values, as I say in the Constitution, you have to go back and find out those values. They haven't changed a lot. The fact that freedom of expression was important in the Enlightenment, it was. So is freedom of religion. So were a lot of those things. And those are the values that underlie the word liberty, etc. But in my own view, to use sort of a slightly rhetorical example, which I did, George Washington was not aware of the Internet. I mean, I think we agree on that. And so most of our job is applying those values, which don't change very much, to a world that changes a lot. And the freedom of speech, those words don't explain themselves. They don't tell you how they're going to apply to a really tough case where the Internet wants to communicate something that's of private information about an individual. Which is it? The right of privacy, or is it the right of expression that predominates there? Very hard. And so if I had to incorporate in 4 words, I'd go back to a judge who was in the 18th century. I found it in Gordon Wood's book, in Connecticut, near Rhode Island. right. But in Connecticut, who said, Root, I think his name was, and he says, the American tradition of judging involves prudence and pragmatism, reasonableness and utility. Well, I think those are elements of an effort by a judge in a difficult case to work out how those ancient values apply to modern circumstances.
I have no problem with applying ancient values as they were understood at the time to new modern circumstances. Originalism doesn't mean that the radio is not covered by the First Amendment. Of course, you have to apply the text of the Constitution to new phenomena. But what originalism suggests is that as to those phenomena that existed at the time, the understanding of the society as to what the Constitution prohibited at that time subsists. For example, the death penalty. Now, there are good arguments for and against the death penalty. Is it prohibited by the Eighth Amendment? For an originalist, the answer is easy. Of course it isn't, because it was the only penalty for a felony when the Eighth Amendment was adopted. Nobody thought that the death penalty was prohibited. It continued to be used in all the states. Nonetheless, I've sat with 4 colleagues, all off the court now, who thought the death penalty is unconstitutional. That's the difference, essentially, between a living Constitution approach and an originalist approach. Of course I will apply, and when I apply the original values, I apply it as those values were understood by the people who adopted that amendment, so that I look to see what they thought was prohibited and try to carry that forward to these new phenomena. That's the basic difference between originalism and the living Constitution. I don't trust myself to be a good, what should I say, a good interpreter of what modern American values are. You people are much better at that than I am. I have very little contact with the American people, I'm sorry to say. You do, and the members of the House probably even more. So if you want to keep the Constitution up to date with current American values, you ought to decide what it means, and you could, kiss us goodbye.
Thank you.
Well, yeah, I'd add one thing, that we have this discussion from time to time in public. We've had it before. It's very interesting, I think. I don't know if the audience thinks so. And I have a lot of good arguments and counter-arguments, but I can't resist asking him to make what I think is one of his best arguments, because it's so funny. When I produce really, really very good arguments, I think, he responds with a joke.
About the bear? Yeah, the bear. What bear?
I can't remember his joke. This is what his joke is.
No,
So every time I think I've really got very good arguments here, what he says, well, it's like the two hunters. His view, we got what I say. So
Oh, okay, I'll tell it. You won't tell it. All right, no, there are those people who are always criticizing originalism because it's not perfect. That you have to figure out history and whatnot, and that's so difficult. And my point is, I don't have to show that originalism is perfect. I just have to show that it's better than anything else. And the story is about the two hunters who are out in the woods in their tent, and there's growling in the brush near them, and they open the tent flap, and there is a huge grizzly bear, and they start running. And the guy who's a little heavier and he's running behind, he says, "It's no use. We're never going to outrun that bear." And the guy who's running in front says, "I don't have to outrun the bear. I just have to outrun you." And, it's the same thing with original. I just have to show it's better than his. I don't.
Justice Scalia, you remember my son Mark, who used to play when he was 8 or 9 years old, soccer with your son. We used to stand there sometimes rainy Saturday mornings watching these games. Then went on the Marine Corps. One of his Marine buddies, he and one of his Marine buddies ran a marathon through a game park in South Africa with lions roaming around. He remembered that. He used your line. And I must admit, in 35 years on this committee, this is the most unique discussion we've had in the committee. Senator Graham.
Thank you, Mr. Chairman. Yes, it's unique and fun, too. Let's talk a little bit about some high school students out in the audience. How do you become a judge at the federal level?
appointed by the President of the United States.
Okay.
There's an Irish saying, Senator, good luck beats early rising.
Right.
Often on recommendation of the Senator.
And from a politician's point of view, when you pick a judge, you make one end great and 10 people mad at you. So it's a political decision under our Constitution. Is it fair, Justice Scalia, for a president to look at the philosophy of a person they would like to nominate to the judiciary?
You know,
Who appointed you?
Ronald Reagan appointed.
Do you think it was an accident Ronald Reagan picked you? You think he went through the phone book and said,
No,
hey,
look,
this looks
look.
like a good guy?
The Europeans sometimes criticize our system because of the political appointment of judges. I mean, when you place the appointment in the president or in the Senate, you guys don't touch anything that it doesn't become political. It should be political.
And to any high school student out there, I think it should be. And we're going to have an election in 2012, and one of the issues will be, what kind of judges will you pick if you get to be president of the United States?
There's nothing wrong with that.
As a matter of fact, I think it's healthy for the public to say, when I vote, the Supreme Court does matter, the lady at the supermarket. I really should think about who I'm voting for because the court does have a lot of power, and I'm going to consider that. Is that okay, Justice Breyer?
Yeah, but you have to keep a couple of things into account. And one is when you put on the robes, you take off the politics.
Well,
and that's over and over. But that's not your. I'm not going to just. I'm
like
not
where
going to
I'm
stop.
going if you just hang in there with me.
Yeah.
Okay. So the whole idea that a Republican conservative would campaign on picking conservative judges is not only okay, I think that's to be expected. Do you both agree with that? And a liberal Democrat?
Well, here's my caveats. One, very often at any level of detail, the presidents have been disappointed. Teddy Roosevelt said of Oliver Wendell Holmes, who 3 months decided the opposite way on an antitrust case, he said, I could carve a judge with more backbone out of a banana. And presidents are sometimes disappointed even at the level of general philosophy.
Absolutely.
And that can happen. But as far as asking me in a way about the rest of it, is I've said, I say this a lot, so I might as well repeat this joke because it has some point to it, that when I'm asked about the confirmation process and the nomination process, I remind people that I was the person who was nominated. I was not the nominating person. I was the person who was confirmed. I was not the confirming person. And to ask me about those processes is slightly like asking the recipe for chicken a la king from the point of view of the chicken.
Okay. Fair enough, but that doesn't mean I can't keep asking.
No.
Senator, can I agree that politics, it's a political check on the court. When the court gets too big for its britches, the one check is the political confirmation process and appointment process. However, in my view, when the court is operating properly, when it is not applying its own view of what the Constitution ought to be, but is interpreting text as lawyers do, understanding the meaning of those words and the history behind those words, there's a lot less less need. Twiddledum and Twiddledee. I mean, there's no such thing as a Republican good lawyer and a Democrat good lawyer. You're either a good lawyer or you're a bad lawyer.
I couldn't agree more, but the point I'm trying to make is that we do have a political person appointing judges, and political people confirm the judges. That's the way it works. And from a Federalist point of view, Justice Scalia, since I haven't read all the Federalist Papers and don't expect to, and that probably says bad things about me, but at least I'm being honest, should a senator say no to an appointment because it's of a different philosophy than the senator himself or herself would have chosen?
Senator, I have views on that, but I don't think it's appropriate for me to express them.
Okay.
I leave
Under
you,
our
I leave you alone, and you generally leave me alone.
Okay. Well, let's talk about the confirmation process. You both have been through it. How many votes did you get, Justice Scalia?
98, Senator.
How many did you get, Justice Breyer?
No, I think I only got 88, but who's counting?
Okay. I bet you remember the 12, too, don't you? The point I'm making is that since I've been here, it's getting more and more difficult to get someone through the process. And do you worry at all that the confirmation process, if it gets too out of hand, will have a chilling effect in recruiting the best and the brightest? Is that a concern at all to members of the court?
Oh, I think it's had that effect already at the Court of Appeals level.
What is the biggest threat to an independent judiciary as you see it in America right now?
Well, this will surprise you. My view is federal judges ain't what they used to be. When I got out of law school, there were 67 Court of Appeals judges, 2/3 as many as senators. It was a big deal to be a federal Court of Appeals judge.
Can I interrupt you? And I
Yeah.
hate to do this. 2/3 of the people coming to the judiciary today come from the public sector. 30 years ago, 2/3 came from the private sector.
I was getting to
We're
that.
becoming a European model.
That was my point.
Good. I only got 18 seconds, so we
Okay.
got to get there.
That's
Okay.
exactly my
Right.
point. And the main difference in my mind between the common law system and the European system is the difference in the character of the judges. In the European system, the judge is a bureaucrat who has been a judge all his
And
life.
I would argue that we are creating, because of pay problems, confirmation problems, we're going to gut our judiciary of the best and the brightest if we don't watch our politics and the way we take care of our judges. Would you please comment, Justice Breyer?
No, I
What do
think
you
there's
the big-
much truth to that. Much truth to that. The great thing I think in the federal judge is that the federal judge always was, and I would hope always will be. The federal district judge is where it's important too. You know, a federal district judge is a local person, and he understands or she understands that community, and he or she will sit on the bench. And this is a fairly high-level official. And that official will make it apparent to the community that he or she is willing to give up that personal time face to face with anyone in that community, rich or poor, who has a problem that calls for the work of the judge, and that time is given. That is not a bureaucrat, That's not an administrator. It isn't an elected official. It's a different job. But here in this country, this person who's supposed to be and is a pretty high-level official gives you the time, Mr. or Mrs., you see, that your problem calls for. And that's shown in the way the courthouse looks. It's shown in the attitude of the judge. It's shown in the way the community responds to the judge. And all of that is part of an institution. And institutions are not built overnight. And they can be hurt. And so if the thrust of your question is how do we maintain the strength of what's really been a unique institution in the world, and it isn't just the Supreme Court now. It's that entire federal judiciary at all levels. And I'm glad you're interested in that. And I think it is a problem. And I don't have a definite solution, but some of the things you've mentioned are certainly part of the mix.
It isn't just the pay, it's also the numerosity. And the numerosity goes back to the laws you pass. I think it was a great mistake to put routine drug offenses into the federal courts. That's just routine stuff that used to be handled by state courts. If you want excellent federal judges, you want an elite group, and it's not as elite as it used to be.
Well, I would note that I agree with you on that. There is having been a prosecutor in a state system, there are too many things going to the federal system. And I also note Senator Graham raises some very good questions on this, and I know we have pending right now, waiting to be confirmed, stalled on the floor by objections, I guess, somewhere, judges that would represent over 100 million Americans who have vacancies today. Chief Justice has said that we ought to, he's called it critically, he spoke of the critically overworked districts. Frankly, I think we've got to do a better job getting these people confirmed. I don't care who is president. But we also, Justice Scalia, there are too many things that before federal courts. They should be in the state courts. It's like the old days of J. Edgar Hoover. We wanted to, if you found a stolen car, they wanted to claim it so they could say how much money they had recovered. It's not the place. Senator Durbin, Senator Blumenthal has yielded. You go first, and he'd go next. But Senator Durbin.
I want to thank my colleague from Connecticut in his debt, and thank you both for being here for this historic meeting of the Senate Judiciary Committee. Most people are not aware of the fact that we have a rather unique dinner where the Senate visits the Supreme Court, and we have a chance to break bread with our families and have an informal moment. And I won't give this justice's name, but the last time we got together, I mentioned to one of your colleagues who's been on the bench for some period of time that I was chair of the subcommittee on the Constitution, civil rights, and human rights. And I asked your colleague, without attribution, if I could ask you, what do you think I should be taking a look at in that constitutional subcommittee? Gauging issues that come before your court, the constitutional questions that present themselves to our generation under the civil rights, human rights category. And it was interesting. That justice's response was, you ought to take a look at the number of people who are in prison in the United States of America. I'm aware of it, and I'm sure you are too. Over 2 million people incarcerated in our jails and prisons, more prisoners per capita than any other country in the world, obvious overcrowding, and terrible racial disparities in terms of those who end up in prison in our country. African Americans, 6 times the rate of Caucasians, incarceration. 2009 studies show that 1 out of every 11 African Americans is in prison, on parole or on probation. Senator Sessions and I joined forces in a rare bipartisan show here and addressed the crack cocaine sentencing disparity. I think we could have done it differently, but we reached an agreement, and that's pretty historic when you consider the different philosophies that were part of that agreement in an attempt to reduce some of this incarceration. I'm not going to hold you to that particular issue, but ask you if you would like to comment. Where do you think we should be making inquiry at the congressional level when it comes to our Constitution and the challenges we face today?
Well, we're thinking, I think it's fine that you're going into that. And sentencing is part of that. Mandatory minimums are part of that. There are a whole range of things, and there have been articles in the newspapers about all kinds of elements which are not within our control necessarily. But I mean that are really within your control in the sentencing area, the prosecution area, the criminal area. That's a huge matter, and I'm glad you're going into it.
I don't want to confine you to that. If there are other issues that you think are worthy of at least inquiry at this point.
I'm going to pass. This is within the category of, I leave you alone, you leave me alone. It's your call. It's a policy question. I don't.
It's a policy question.
I don't really want to get into it.
Yeah,
All right. And this relates to the question of ethics, which it turns out is handled differently in our different branches of government. As someone who has been involved in political campaigns and public service for a long time, I obviously know the need for us to not only be honest in our dealings, but to have the appearance of honesty in our work. Our major ethics laws accomplish this by imposing certain restrictions. For example, every other member of Congress, our staffs, the entire executive branch of government, and all federal judges are restricted from receiving certain gifts and outside income under the Ethics Reform Act of 1989. The members of the Supreme Court and its employees are the only employees of the federal government who are exempt from these restrictions. Do you believe the Supreme Court should be required by law to follow the same financial restrictions as everyone else in government?
Oh, no, we are. I certainly have thought so. We file these long reports every year. It's quite expensive to prepare. Where every penny that I take in, or my wife, or minor children, every asset has to be listed in depth, and it's all filed. And the amount of money that you can take from anyone outside is far more limited, I believe, under the codes of ethics than people who are not judges. Judges have special restrictions there. And so I don't think that the life of the judge in terms of ethics is less restricted than the life of any other member of the government, to my knowledge.
I'm not. Incidentally, I should preface this by saying no reflection on either one of you.
Yeah, I understand.
But I would just say I anticipated that answer, and I understand that the court is bound by these restrictions by a court resolution adopted 20 years ago in 1991. And I wonder if you could tell me about that resolution. It is not public law like the Ethics Reforms Act. Would you agree that this resolution should be more public?
I think there's several different things. I think one is what money you can take or can't take for the most part, what the reporting requirements, and some of the general ethics requirements that are you can't sit in cases. Those are statutory, and I think they bind us, period. I've always thought so. I mean, I've never heard to the contrary. Now, there's some that are just in this ethics volume. Which, that's probably what you're thinking of. And if you were to ask me, well, which ones are they specifically, I couldn't answer. I don't know. But there are some that fall in that category. So probably like most of us, I have this used to be 7 volumes, and before, if I had an ethical question of when I'd recuse myself or something, I'd go look and see what they say. And I didn't distinguish in my own mind whether they're legally binding or whether they're something I just follow. So I'd read them, and if I have a problem, I call an ethics professor. And everybody has some such system. They have to figure out. There's no one who wants to violate any of those rules. Now, there is a big difference between the Supreme Court and the lower courts. And the difference is simply this. When I was on the Court of Appeals, if I had a close question, I'd take myself out of the case. They'll put someone else in. One judge is as good as another, frankly. But if I take myself out of the case in the Supreme Court, that could change the result because there's no one else to put in. And the parties, knowing that, I'm not saying they would, but it's possible to try to choose your panel, which is undesirable in the Supreme Court. So what that means is that there's an obligation to sit where you're not recused, as well as an obligation to recuse. And sometimes those questions are tough, and I really have to think them through, and I have to make up my own mind others can't make it up for me. And that's a very important part, I think, of being an independent judge. We're given tough questions to answer, and so the answer is, A, there's a big set where we're bound by law. B, there's a set where we may not be bound by law, but we're bound in practice. And C, in that set, whether it's law or practice, we, I think, have to think it through and try to work out which is the predominant force there.
I don't have any more time left, and I don't want to disadvantage Senator Blumenthal, but my next line of questioning was how much of this should be made known to the public.
No, I've just made it known to the public.
The question is whether, for example, we make disclosure as members of Congress that would lead to conclusions as to whether we're in a situation. I don't believe the same public disclosure is made at the Supreme Court level, is it?
Yeah, it's pretty much, I can't say 100%, but I mean, if there's a difficult question, usually there's a press inquiry. And I know, sometimes we write opinions about it, and usually the press gets an answer. And so I'm not sure that there are things that matter where, like I have to take myself out of quite a few cases because my brother's a judge in San Francisco. And so if I'm recused or I take myself out because he was sitting on the case, I usually tell Kathy Arberg, our press officer, I say, well, this is normally off the record because I don't want a long article, but I'll say just tell them the reason I'm not in that one is because my brother's in it, okay? And so I don't think there's some kind of secret thing that goes on. I can't prove it so in every case, but I can't think of any case.
Thank you. Thank you, Mr. Chairman.
Thank you. I'm going to go to Senator Lee, but I just wonder if I might have your indulgence. And you could answer this one very quickly. You talked about if one of you has to step out, there's nobody else to step in. We have 3 retired Supreme Court justices now. In all our courts of appeals and our district courts, those who have taken senior status can step in if there's been a recusal or necessity. How would you feel about allowing former Supreme Court justices to step in if there's a recusal?
Who's going to pick the former Supreme Court justice to step in?
I would assume the chief.
Yeah. Well, I don't think that'd make anybody happy. To tell you the truth.
Then how about the remaining 8?
Don't know. I mean,
By majority vote.
I don't know that that'd make anybody happy either. And what if it's 4-4?
Then you don't have somebody.
No, I think we can stumble along the way we are.
You're getting the reaction, don't change anything, but that's the, I haven't really thought that one through. It sounds, there might be problems. I don't know.
I may chat with you more about this one. Senator Lee, thank you very much.
I don't think it's much of a problem, Senator. There's very few cases where we affirm by an equally divided court. How many last term?
Very few. There's some occasions.
It's very rare that happens.
Thank you. Senator Lee.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement. Along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry, since we're talking about federal legislation, these would, of course, be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce. But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the board of directors of the American Kennel Club. That passes both houses of Congress. It goes to the president. It's signed into law. And we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a sentencing commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it. I didn't think that was constitutional. So I am sure I wouldn't like your dog breeding body either. But I can't speak for the court. I don't know what the court would allow.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly. You have to be careful, because John Jay, I just read this in John Stevens' book. It's pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer.
And he was right. And his tenure on the court proved to be short-lived in any event.
Now, the situation you pose is quite different, of course, from your leaving it to an agency.
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency, because you are increasing the power of the president. You're a competitor to the president. The separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
So the difference, you would insist, is based on the fact that this is an executive branch agency, which, at least in theory, is subject to the disposition, subject to the control, to the direction of the chief executive.
I think that's right, and I am. What can I? You're talking about the doctrine of unconstitutional delegation of legislative authority, which is a bad name for it, because there is no such thing as a constitutional delegation of legislative authority. You cannot delegate legislative authority. Now, when you give rulemaking to an agency, how far can you go? Can Congress just get together and say, the president can do anything he wants and adjourn? Of course not. That has to be unconstitutional. But is it up to the courts to decide where the line is drawn between giving enough authority to the chief executive and too much authority? It is simply a non-justiciable question, and I, for one, would not let the courts apply the doctrine of unconstitutional delegation, where the delegation is to the executive.
As long as it's to the executive branch agency, then even
I wouldn't get into it. Some of my colleagues would, I suppose.
Even in the extreme situation where we passed a law saying, for example, we shall have good law. The power to make good law is hereby delegated to the Department of Good Law, which is hereby created.
I'd do that one, all right. But that's not going to happen. I'm talking about any real situation. I can't imagine my sticking my toe in that water.
Okay. And Justice Breyer, I had a question for you. I've really enjoyed reading parts of your new book, Making Our Democracy Work. It's very well written and fascinating. I think it's good reading for any law student or lawyer or American who wants to learn more about the system. You suggest in your book, at page 126, that there's rarely an easy answer to the question of what level of government should be primarily responsible for helping to resolve the problems that potentially call for legislation, and that the question usually turns on empirical information such that facts help determine the answers. Yeah. You go on to explain in pages 125 and 126 that very often this means that the courts ought to step aside and, if I'm understanding you correctly, have Congress more or less decide the precise contours of the boundaries of federalism. Is that, am I understanding the book correctly in that regard?
Yes, that's right. I think it's, because you go to abstract, but it's if you start talking abstractly, the trouble is you can characterize any individual situation usually in 15 different ways at different levels of abstraction. And depending on how you characterize it, it'll seem appropriate for a federal answer, or it'll seem appropriate for a state answer, a local answer. Is it a police department problem? You say, well, it's arresting somebody. Yeah, but arresting them for having guns. And, well, it's a state problem. Well, but the guns are torpedoes and they're only made internationally. And so that's so complicated and difficult that it's hard for the courts to find a general principle there. That's my point there, and that's why.
So if that's the case, and if it's also the case that under, as we read in Federalist Number 45, the powers of the federal government are few and defined, whereas those of the states are numerous and indefinite, then members of Congress should read the Constitution, decide what those contours are, and restrain ourselves rather than waiting for the courts to step in and say, no, you've overstepped the bounds.
No, my point that I was making there is you are elected by officials in a state, and so you will make such judgments on such matters as you believe are appropriate in light of how people, partly how they feel and partly what you're trying to represent, but that it is a lot of that is your decision.
Right. Senator, of course you have to make those constitutional decisions. You take the very same oath that I take. The only reason I can look at a federal statute and say I have to disregard this because it does not comport with the Constitution, the only reason is that I've taken an oath to uphold the Constitution. You take the same oath. So, and we give deference to legislation on the assumption that the members of the Senate and of the House have tried to be faithful to their oath. And if indeed they're not even looking at or even thinking about the constitutionality of it, that presumption should not exist. So yes, of course you.
So in that respect and to that degree, our oath to uphold the Constitution, our commitment not to overstep the bounds of federalism, means more than simply doing that which NLRB versus Jones and Laughlin Steel or Wickard v. Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said. But we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them. Where your law does not comport with the Constitution, it seems to be a law but really isn't, and so we ignore it and apply the rest of the law, the statute notwithstanding, as one of our early cases put it. But it's really you have the first cut and the most important cut.
Thank you. Thank you, Mr. Chairman.
Next we'll go to Senator Blumenthal, and I thank you again for letting Senator Durbin go out of order.
Thank you, Mr. Chairman, and thank you for having this hearing. Thank you, Justice Breyer and Justice Scalia, for spending so much time with us and having so much patience with our questions. Before coming here, and as you may know, I'm one of the more junior senators. I was Attorney General of the state of Connecticut, didn't have the honor of knowing Mr. Root for about 20 years, and the highlight of those 20 years was the cases that I argued before your court. So I have been waiting for the day.
This is payback, huh?
When I could interrupt you as mercilessly and relentlessly as you did me, and give you as hard a time. But fortunately, in those cases, I think there were 4 in all that I argued. You decided the right way, so I'm going to avoid the temptation. But I was very impressed and moved by your explanation as to why you think it is so important for the public to understand and appreciate what judging is and what role it plays in our system. And I agree with you totally that not only is there the need, but there now is the lack, really, of that understanding. And so I guess I say, as not only one who's argued, but also as a former law clerk who sat through a year of arguments and learned so much about the system in that process, why not open it to video recordings? Why not, in the federal courts, give the public the benefit of seeing it firsthand in your court and other federal courts, and so appreciate really the quality as well as the diversity and the extraordinarily often excruciating difficulty of what you do?
I'll start. Senator, when I first came on the court, I was in favor of, you're just talking about televising the arguments, right?
Correct.
Not the conference. You know, the Brazilian Supreme Court, they televise their conference.
I would never presume or think of televising it.
Nor would I.
I was initially in favor of televising, but the longer I've been there, the less good an idea I think it is. Now, the justification usually put forward is we want to educate the American people about what the court is and whatnot. Now, if I really thought the American people would get educated, I'd be all for it. If they sat through days of proceedings gavel to gavel, boy, would it teach them a lot. They would learn that we're not most of the time looking up at the sky and saying, should there be a right to this or that? That we're doing real law, the bankruptcy code, the internal revenue code. People would never again come up to me and ask, as they sometimes do, Justice Scalia, why do you have to be a lawyer to be on the Supreme Court? The Constitution doesn't say so. No, of course it doesn't. But 99% of what we do is law. It's stuff that only lawyers can do. And if the people would learn that, it'd be a great piece of education. But for every 10 people who sat through our proceedings gavel to gavel, there would be 10,000 who would see nothing but a 30-second takeout from one of the proceedings, which I guarantee you would not be representative of what we do. So they would in effect be given a misimpression of the Supreme Court. I am very sure that that would be the consequence, and therefore I'm not in favor of televising it.
But it would for high school students or even middle school students and for the general public who were interested in an important and pertinent case, provide a means for them to see what right now only a very limited audience can view because of the size of the court.
Yeah, but for those who are interested in it for those intellectual reasons, surely the tapes are good enough.
Well, the tapes, with all due respect, and I understand your argument, don't convey in the same way with as much interest the kind of debate, the back and forth, the visual sense of the action in court, and I know and you know really how dramatic it can
be.
be.
You just sit there like 9 sticks on chairs. I mean, there's not a whole lot of visual motion. There really isn't. It's mostly intellectual motion.
Well,
that's
I can say it certainly is gripping if you're answering the questions. Justice Breyer, do you have a different view?
No, I sort of, a little, but I think we're conservative. And you would be too if you're there. The court has lasted the country well and served the country well over a long period of time. We're there for a short time. We're trustees. And we don't want to make a decision that will be non-reversible and hurt the court. So you start there. And then sometimes I think, when we had the term limits case out of Arkansas, I just wish people could have seen that. It was such a good case. I mean, you had Jefferson and Story on one side and Madison and Hamilton on the other side, and it was the term limits.
Yeah.
It was, and what you saw is everything evenly balanced with the precedent. And what are the? I won't go into the case, but if they could have seen that across the country, people would have been able to see in that oral argument 9 individuals struggling with an important constitutional question that would have been good for the court and everybody. All right, so what's the problem? Well, one problem is that we're a symbol, and if it were us in our court, it could probably be in every criminal case in the country, and you would get rid of what? What do we do it with jurors? What about the criminal witnesses, etc.? And you don't know what happens with symbols. Or would people come up with a misimpression, namely the oral argument's 5% of the case, 3% of the case. It's really done in writing, and they don't see that. And more importantly, people relate to people. You relate to people. I do. When you see them, they're your friends or you're not your friends or whatever. But we're making decisions that are there to affect 309 million people who aren't there. And in our minds, we have to take those 309 million into account. And will that come across? And then there is the problem that Justice Scalia mentioned, which is, Nino says quite right. How do we, you can make people look good or you can make them look bad, depending on what 30 seconds you take, and it's already cult of personality, and let's not make it worse. We wear black robes because we are speaking for the law, not for ourselves as individuals, and that's a good thing. So add those up and you say, I don't know. I would like to know more. I really would. There are places that have it and don't have it. There are courts that have it and others that don't have it. There's Canada that has it. There's California in some situations. You have 100 different situations in respect to that. Why can't we get some real information, not paid for by anybody that has an interest in this, but Pew or some of the foundations, and see what happens to attitudes, to judicial attitudes to others. So what you're getting, I think, and maybe eventually, it's going to be there's no other way to see things but visually, and everybody's doing that, and then it won't even see it. Just seem weird what we do now, and then it'll all change. But before that time, I think when that's a little boring, but I think information is something that would make me easier. And until I become easy about it, until we become reasonably convinced that won't hurt the institution, you're going to get a conservative reaction. That's what I think is the truth.
Senator, it's maybe unfair to put this question to you since you're such a youngster here, but do you really...
That's the best thing that's been said about me in a long time.
Do you really think the process in the Senate has been improved since the proceedings have been televised?
Well, just as you took a pass earlier, I think that there are mixed views, but in general, I think that openness and transparency improves institutions. And for all the reasons that you have so eloquently talked about your role in educating the American public, I think that an audio and visual recording of Supreme Court proceedings would potentially do the same. And I think that whatever the results of televising Senate proceedings, and I was only facetious when I said I would take a pass, I do think that it has been a step in the right direction of providing more transparency and disclosure and understanding on the part of the public. Now, I'll let you and the public be the judge of how it views us, but I think in general, Americans should understand the challenges as well as the role that their institutions face. And my time has expired, and I want to thank you again for being here, and I am not at all dismissive of the points that you've made. On the contrary, I have great respect for them, but perhaps we can provide you with some more information that would be persuasive in the advantages and the positives in those kinds of greater availability or accessibility. So thank you for being here today. And I also want to thank you for raising the issue of state courts, because I am one who has spent a lot of time in state courts. You often have to consider the results of state courts, and all too often we in this body fail to understand how integral the state courts are to dispensing justice in this country. Thank you.
Thank you very much. And Senator Sessions.
Thank you, Mr. Chairman, and thank both of you for attending and comments and insight. I hope the young people have appreciated this. I would say to the young people, having traveled around the world in this years, We have the greatest legal system in the history of the world. We really do. It's a marvelous thing of inestimable republic. People can rely on in court. They can invest large amounts of money. They can place their and feel like consistently they're getting a fair day in practiced virtually full time before federal judges as assistant United States attorney for 14 years. When I had the law on my side, I almost always won. For me, if the law wasn't with me, I lost. I think that happens in courts pretty much all over America, and judges try to do that. I do believe it is law, and it does take a lawyer to dig through these matters and understand the precedent. But I guess what I'd say is American people do care. They have a high court. They believe that you should follow the law, and the greatest threat to the court, in my opinion, is if the American people believe that judges are consistently redefining the meaning of words to advance their agenda, views, whether conservative or liberal, and that law is the essence of what you do. And I just, my own, the political world and the legal world. And with regard to Senator Graham's comment, I think there's an area which we can respect as to the more activist or the more living constitutional view of the Constitution. But if it goes beyond that, in my view, the judge should not be confirmed. The nominee should not be confirmed. I have to know that when they say that they understand they will serve as the oath does under the Constitution and under the law, that they're willing to comply with that. So that's how we wrestle with these issues, and each senator has a different standard. Professor Van
Don't scare me, Senator.
No. Professor Van Alstyne made a speech to the 11th Circuit one time, and he said the essence, what he called on the judges to do was, in his view, to enforce this Constitution. It concludes with, or we establish this Constitution for the United States. Yeah. And he said, the good and bad parts, whether you like it or not, in the long run, that document will be stronger and a greater bulwark if the courts enforce it as it is written, this Constitution. Would you agree with that? I'll ask you both just to discuss that point.
Yes, sir. I certainly do, and I don't think I've said this in some talks. I think that the what shall I say? The controversial nature of recent confirmation proceedings is attributable to some extent to the doctrine of the living Constitution, because when you indeed have a Supreme Court that believes that the Constitution means what it ought to mean in today's times, it seems to me a very fair question for the Senate to ask, or for the President to ask when he selects the nominee, what kind of a new Constitution would you write? You know, do you believe this new right is there, or this old right isn't there? That seems to me it's much less important whether the person's a good lawyer, whether the person has a judicial temperament. What's most important is what kind of a new Constitution are you going to write? And that's crazy. I mean, it's like having a mini constitutional convention every time you select a new judge. So I'm hopeful that the living Constitution will die. And
I mean, note what you said. Of course, I agree with that. It's this Constitution. You see, I said Constitution because I'd want you to think of John Marshall's famous words. It is a Constitution that we are expounding. And he's thinking that that document has to last us for 200 years. And as I say, that doesn't mean you change the words. But the hardest problem in real cases is that the words life, liberty, or property do not explain themselves liberty, nor does the freedom of speech say specifically what counts as the freedom of speech. And therefore, there is a job, and lower court judges come to different conclusions on the same difficult question of what happens when you're on the internet and you reveal somebody's personal information and then it's picked up in a newspaper, and how does the freedom of expression invade there? Does it extend to that invasion of something the person would like to keep personal, and does it depend on who he is, In other words, it's very complicated. And trying to apply this Constitution with those values underlying the words to circumstances that are continuously changing is not something that can be done by a computer. Neither of us thinks that. No one thinks that. And therefore it calls for human judgment. And as soon as human judgment enters the picture, fallibility is possible. And then some of us think that, but by really reading that history carefully, we can get answers. And beware of the judge like me, all right, who tries to look to see what are circumstances now and how does it fit today, because there is a risk with me that, unbeknownst to me myself, I will become too subjective and will tend to substitute what I think is good for the Constitution as it was written and intended to apply. And what I say is, yes, you are right about that, and all I can do is be on my guard, write my opinions, try to look to objective circumstances, and I see the opposite danger. The opposite danger is called rigidity. The opposite danger is interpreting those words in a way that they will no longer work for a country of 308 million Americans who are living in the 21st century. Work in the way those framers would have wanted them to work had they been able to understand our society. And all that's in those words. It is a constitution. We are expounding.
Do a polling data, or do you have a hearing to determine whether it will work or not, like Congress does, or do you just...
What do you do?
Well,
you have to look at the examples there. What's a good example where we didn't agree? There is there are cases when you say, will it work? What you're doing is looking to what are the free speech consequences? We had a case where somebody took a tape recording of something that was in the public interest, but involved somebody's personal conversation, and then threw it over the transom into a newspaper. And they printed it, and there was a law saying you couldn't wiretap to get that information. And how did that all fit within the framework of free expression? And so what you try to do is try to see what are the risks to the expression, what are the expectations of the individual. And you have 42 briefs filed that are helping you on that. So I've said what the basic...
Those are new phenomena, Stephen. Yeah. We're not talking. You and I don't disagree very much.
Oh, you see, he's right with me on that. I don't know why he didn't join my opinion.
You have to calculate the trajectory of the First... But let's take the First Amendment, the freedom of speech. It was absolutely clear when the people ratified the First Amendment that libel was not part of the freedom of speech, and that included libel of public figures such as you gentlemen. But the Supreme Court, in a case called New York Times versus Sullivan, a marvelous example of the living Constitution, just decided it would be a good idea if there were no such thing as libeling a public figure, so long as you have somebody who told you this, that you believed. Now, I think who authorized the Supreme Court to change the law? That may indeed be a very good rule, and the people are free to adopt that rule by legislation. New York could have amended its laws to eliminate the libel for public figures. So don't charge inflexibility. What's inflexible is the inability now to change the libel law that the Supreme Court has instituted through New York Times versus Sullivan. It may be a good law, it may be a bad law, but you can't change it. Nobody can change it. I guess we can change it.
Mr. Chairman, could I just thank both of these witnesses for their great comments. I would note, Justice Breyer, that I vote for well over 90% of President Obama's nominees, but I do think we have a range in which, if you believe they're too flexible about interpreting the Constitution, then I would conclude they're not faithful to the Constitution. Okay. And therefore, I couldn't support them, even though they may be wonderful, decent people, intellectually gifted in that regard. So it's, and one of my standards is a death penalty case. Any judge that says the U.S. Constitution calls for the elimination of the death penalty really shouldn't be on the bench. At least they won't get my vote for the bench. But we all have individual standards, and we wrestle with that. But all in all, we've got a great judicial system. I congratulate you.
Thank you. Thank you. Thank you.
Resisting temptation. The Senator Whitehouse will be our last person to question. I can't thank the two of you enough for being here, and I'll say something after he finishes. But Senator Whitehouse.
Gentlemen, let me join the chairman in thanking you for being here. As two individuals who've been here for the confirmation process, I'm impressed that you're willing to return.
It wasn't bad for either of us, I don't think.
It's gotten livelier. We've talked a lot today about the role of the judiciary in the larger American system and architecture of government. And I wish you'd say a few words about the role of the jury within that architecture, and whether or not you see the jury as just a little piece of fact-finding machinery for dispute resolution, or whether the founders and you saw and see a larger role for it as an political small p institution in our system of government. Is it an important piece of our governmental architecture as well as our dispute resolution system? And if so, how?
Absolutely is, which is why it is guaranteed in the Bill of Rights in criminal cases, and indeed in all civil cases at common law involving more than $20. The jury is a check on us. It's a check on the judges. The framers were not willing to trust, in criminal cases, the judges to find the facts. Indeed, at the beginning, when the Constitution was ratified, juries used to find not only the facts but the law, and this was a way of reducing the power of the judges to condemn somebody from prison. So it absolutely is a structural guarantee of the Constitution.
I think it's very important. I've never been a district judge. I was an appeals court judge, but my brother is a trial court judge, and I was there a while ago in San Francisco, and he said, "I want you to see me select a jury. You shouldn't go through your life." I was on a jury in Massachusetts, actually. I got selected. But he said, "You shouldn't go through your life without seeing that." And he said, "Congratulations, at the end, you and Justice Sotomayor now know how to select a jury, at least a little." All right, I saw a morning pass, which was just terrific. You take 12 people randomly from that community and 2 alternates, and by the time they're finished, they're thinking that there is this future of this individual who is the defendant is in all likelihood in our hands. And they take that because of the instructions and the way the lawyer behaves as a very, very, very serious matter. And they are participating. They are part of the government of the United States. And you begin to think, it's really a wonderful thing that before you deprive a person of his or her liberty, you go through this process where the community is brought in as really judges of the facts. So they aren't just a fact-finding machine. This is a way of saying to people in a community, it is all of you in this democratic system who will participate in this terribly important matter, a matter of depriving an individual of his freedom. And just listening to the instructions and noticing the jury's reaction. They take that in. And I saw the same thing in the courthouse in Boston, where a room is set aside from that. And they have things for people to read in that room, and the judges talk them in a way that when the person comes away from the jury, and I think most of them do, they're very proud to have participated as a citizen in this exercise of application of community power. So I find that partly fact-finding, partly showing people how they too are part of the government of the United States in its most important processes, and a way of overcoming isolation and bringing an entire community into the legal process. Very good thing.
At the time that the Constitution and Bill of Rights were adopted, my understanding is that the founders also had a fairly skeptical view of governors. The colonial governors had shown considerable arrogance and high-handedness. They were skeptical of assemblies. Thomas Jefferson had described the Virginia Assembly, I think, as 207 tyrants replacing one, and that was not a big improvement. I probably have the number wrong. And I wonder if the stature of the jury in the architecture of American government could not just be as a check on judges, but also as sort of the last bastion where somebody who is put upon or set upon by political forces can get away from the political forces that most lend themselves to corruption, governors, assemblies, and get themselves before a random group of their peers, if the case is right, and that it has a slightly larger significance than just as a check on you all. It's also a check on all of us and the rest of the system of government.
No, I think that's probably right. If you believe that juries can ignore the law, where they think that in this case the law is producing a terrible result, and they do that sometimes, I'm quite sure. And that makes them a check not just on the judges, but of course on the legislature that enacted the law to apply in this particular situation. I'm a big fan of the jury, and I think our court is too.
Let me ask a final question about, jury has this fact-finding role. What is the role of a court of final appeal with respect to fact-finding? And hypothesize that you have a case in front of you from a state Supreme Court, and the state Supreme Court has indulged in fact-finding at the Supreme Court level. What standard of review or deference do you, as the United States Supreme Court, accord findings of fact that have been indulged in by a state Supreme Court that is before you, whose decision is before you on review?
You mean the state Supreme Court has overruled the jury's finding of fact, or just...
It has just made a finding of fact in the course of its discussion. It doesn't have a record to support it, so that's not the issue. Do you credential that at all, or is that
I think
by the boards?
If it's a criminal case that somehow is being appealed to us for a violation of a federal constitutional provision, and if the state Supreme Court has made a finding of fact that is not supported in the record, and if that finding of fact is crucial to the conviction, we would set the conviction aside. Would we not set the conviction?
There's a rule that says that there are two lower courts that hold a particular finding of fact. We won't go into it further. It's an area that I sort of noticed over time, like finding facts we're particularly bad at.
But if the
you
finding
have
of
9 people, and to try to get people to read this enormous record and come to a conclusion is we're just not very good at it. And so we have a lot of rules. So you can never say never. You never say never about anything, but by and large, we stay away from the fact finding.
Well, as the last senator, I stand between you and the exits, and I will not trespass on your patience with us further. Again, I do appreciate very much that you've returned to this chamber and shared your thoughts with us this afternoon.
Thank you, Senator. I think both my colleague and I have enjoyed it.
Well, I think
to our surprise, I might add.
we want to.
We did enjoy it, I agree.
Well, you know what? I appreciate you accepting the invitation. I will put in to the record the letter from the Chief Justice what he was saying very approvingly of these hearings. I think I can speak for all the senators here in both parties. This means a lot that you did this. What I hope it means, too, and I look at the students here, but I hope high schools will look at this. I hope colleges will look at this, not just law schools. That's why we streamed it. We made a copy and everything else. We're in a nation where too many times people look for a bumper sticker solution to everything. I don't care on the right or the left. Things are a little bit more complex than that. And a sense of history never hurt anybody. The two of you have given us a sense of history. I applaud you both for that. And if there's nothing further, we'll stand in recess.
Thank you, Mr. Chairman.
Thank you.
Thanks for that hearing.
Oh, I